This is a presentation on wages and hours under Michigan's Improved Workforce Opportunity Wage Act. The main purpose of the Improved Workforce Opportunity Wage Act is to fix minimum wages for employees within the state of Michigan. It also prohibits wage discrimination among employees via gender, age, and other sorts, provide a wage deviation board to regulate the rules, provide for administration and enforcement of the Act, prescribe penalties for the violation of the Act, and supersede certain acts and parts of other acts. The main goal is to increase minimum wage from the current wage to $12 by 2030. On the next slide, I will show the gradual increases by each year. As seen in this slide, the main purpose of the Act is to increase the minimum wage to $12 by 2030 with gradual increases yearly. I included the minimum wages from 2014 when the initial Act was passed. The Improvement Act was enacted in 2018 where you can see the minimum wage was $9.25. The first year it began was 2019, which was at $9.45 and gradually increases to the $12.05 by 2030. The one exception to this law is that the unemployment rate must be below 8.5% in the previous year, meaning in this year of 2020, to get a minimum wage increase, 2019's unemployment rate has to be less than 8.5% or the wage would remain the same. Other exceptions are overtime will be the same as it currently is. If you work over 40 hours in a 7-day work period, you will get paid 1.5 times your hourly rate. Tipped wages were also under discussion with possible chance of gradual increase to 100% of minimum wage, but it will remain at the current 38% of minimum wage for now. Lastly, a new employee who is under the age of 20 years can be paid a training hourly wage of $4.25 for the first 90 days of employment without punishment. This act started as a ballot measure, but legislature quickly adopted it and passed it as a bill. Michigan Senate and House of Representatives approved the ballot initiative on September 5, 2018, and it went into effect on March 29, 2019. This act supersedes the 1964 Public Act 154 as well as the 2014 Public Act 138. Public Act 154 was a minimum wage law of 1964, which was an act to fix minimum wages for employees within the state and prohibit wage discrimination. Public Act 138 is the Workforce Opportunity Wage Act. This was an evolved act to fix minimum wages for employees within the state and eliminate wage discrimination, develop a wage deviation board, and develop violations for this act if there was a violation. From there, the Improved Workforce Opportunity Wage Act was developed and approved. This bill does have a state counterpart, which is the Department of Labor and Economic Opportunity, also known as LEO, who is ran by Susan Corbin, who runs all operations and is responsible for the labor agencies and unemployment assurance offices. The enforcing body to this act is the Director of Department of Labor and Economic Opportunity, also known as the Commissioner. In Michigan, this is Jeff Donofrio. While Susan Corbin runs the operations and agencies, Jeff's role is to develop programs that help businesses reach their needs and ensure all Michigan employees have equal opportunities in the working environment. The enforcing body makes sure that there is compliance for this act. The Commissioner can request and investigate the wages of the employers at any time. If the employee feels that they have been discriminated against, they can do one of two things. A, within 3 years of presumed discrimination, they can bring a civil action lawsuit against the employer for recovery of the difference of amount paid and the amount they should have been paid. Or they may file a claim with the Commissioner, who will then investigate the claim. The Commissioner can then investigate and bring a civil action under subsection, as well as fine the company for not more than $1,000. Sex discrimination is one way an employer can discriminate against an employee. This is when an employer pays one employee more than another based on their gender. Employers must follow all of the rules, and if they are found guilty of the discrimination, they may not reduce the wage of the employee getting paid the higher pay to comply with the civil action lawsuit. There are a few exceptions to this rule, such as having a seniority system. This is where the pay is based on the length of tenure to the company. Also, having a merit system, where the pay is based on achievements of the employee. Or having a system measuring quantity or quality of production of the employee throughout their period. Or having differential payments based on other factors besides gender. While this is not a Michigan case, it is a federal case for wage discrimination which directly correlates to the Improved Workforce Opportunity Wage Act. In 2018, 4 women filed a lawsuit against Nike Incorporated, claiming they were being paid less than their male colleagues, there were multiple sexual harassment claims, they received smaller bonuses than their male colleagues, and that they were less likely to get promoted. One former brand marketing director even stated she was paid $20,000 less than her male colleague who did the exact same work as her. These 4 women reached out to Human Resources back in 2017 reporting the wage discrimination and sexual harassment claims. Human Resources responded within a month stating that the company was reviewing the potential pay disparities between men and women in the company, and later stated that they identified and corrected the issue, even though there was no data or support for this statement. Therefore, these women then filed a lawsuit against the company. They were demanding court-ordered structural reform of the company's hiring and compensation practices. This case is still ongoing. It has been 2 years, and while there has been progress, Nike is still in debate that they did not allow wage discrimination to happen in their company. In early 2020, Nike was ordered to produce any uniform policies it maintained during the relevant time periods regarding hiring, firing, pay, promotions, and compensations to prove that they did in fact not allow wage discrimination. They are still working on providing those files to the court. While Nike is a billion-dollar company, they have spent over $2 million in legal fees and hundreds of hours in court. Nike feels as though they need to continue to fight these allegations, as admitting to wage discrimination could lead to a poor reputation for their company. Personally, I believe that Nike should admit their wrongdoing, set up new hiring, promotion, and pay practices, and set structure throughout their company. Suggestions for businesses to ensure proper guidelines are followed within the Improved Workforce Opportunity Wage Act. Study policy assurances and provide program manuals. These provide federal and state requirements to this law. It has the rights and authorities given to both employers and employees. It also has rules and regulations to follow. Other suggestions include training programs from Management and Human Resources at Michigan Works. They can provide the company with the correct information to ensure all regulations are being followed. Allow for employee feedback. This will allow management to hear if employees are upset about something and possibly address an issue before taking it to court. Allow them to bring up any issues they may have or discuss possible solutions. That way, the situation can hopefully be resolved before legal action. Go over employee data. While it is not required to have a certain percentage of workers or management be female or a certain race, check for any information that may have gone unnoticed. Maybe discrimination has been happening, but not on purpose. Look at the breakout of employees and the backgrounds of them. See where any issues may arise and fix them before they start. Having a diverse company can help everyone. Have all state and employer policies in a handbook and given to every employee. Ensure they are aware of the policies and procedures and are aware of their rights as well as the rights of the company. That way they are informed of what they will be compensated for. Lastly, have feedback and always keep logs of discussions. Allow discussions and important conversations to happen. This is where learning and growth occurs on both ends. Having annual or biannual evaluations of employees and record that information so everyone is aware of the situation where they're at. If an employee knows where they stand and why they may not be at the same level of someone that they thought they were, they're going to be less likely to bring a lawsuit against the company.